Good morning, everyone. I'm Michelle Lefevre, the Board of Appeals hearing examiner, and this is I'm hearing echoes. Am I hearing echoes? No. This is what I'm calling a recorded work session on a procedural matter related to BA 766D, and they're two interrelated matters, and one is whether or not the appellants complied with the notice procedures in the hearing examiner rules of procedure and as required by Board of Appeals Rule of Procedure 2.206, which are ads and posting and notice requirements, particularly when there's an administrative appeal because the petitioner, who may also be an appellant, doesn't own the property. They can send a copy of the petition and written notification of the time and date of the hearing to the property owner and adjoining property owners, and they shall file an affidavit of written notification with the clerk of the board. And that is the posting and notice requirements relate to a motion to dismiss. I just printed it out this morning, and of course I didn't, but I have a copy in the file. Is it?
I'm hearing examiner. I have a copy. If
It's just the date. It's June 19th?
June 19th.
A June 19th motion to dismiss by the interested party, property owner, Two Farms, Inc. A motion, it's a combined motion to postpone, motion to dismiss based on lack of standing, and the postponement was requested because Two Farms states that it hadn't received a copy of the petition. And when I got, and let me back this up. I'm recording this work session. I know Board of Appeals doesn't record work sessions. They turn off the mics when they go into work session, but the Board of Appeals records. And no, the Board of Appeals doesn't, but the Planning Board records the work session. And the reason that I decided to hold this work session and just put it on the record, because as one person, I'm not subject to public meeting laws, which means I could have decided this outside of the office. And the reason I did this is I was being inundated with emails from multiple persons and getting responses and emails that had no bearing on this particular issue. And I was having difficulty sorting things out. And so I said, what I decided to do Monday night at about 1:30 in the morning was I'm simply going to have a work session where I'm going to go through factually what the record contains. In a work session, the parties are not permitted to argue or comment, and if I have a specific factual question, I will ask you. And it's really simple as that, although it's not that simple, because if ultimately the issue is was the motion to dismiss postponed timely, and that's sort of the ultimate issue here. And I started to try to obtain through emails, but I'm now looking through the record. So what we have in the record about notice is we have two ads that were posted, as I understand, on different dates in the Baltimore Sun. And one is May 26th and one is May 12th. And
Madam Chair, can I ask a question on that? Because I received copies of that, and the notices that Ms. Regner passed on to me was for BA case number 747D.
I have 766D.
Okay, well, that is not what was passed on.
Well, and that's one, again, that's one of the reasons why this said that I have to figure this out here, because, the list of people being copied in on emails kept growing exponentially, and this had essentially, what should have been a very simple matter, and not requiring me to come in and instead of getting my dog groomed, not important, but I decided I had to come in and look at files. So what I had in the file is May 26, 2019, a hearing examiner notice for 766D, June 26, 9:30, Brian England et al., and of course it's too small to read. And then I have a May the 12th ad, 766D, Brian England, June 26, and that's also in the Sun. And the excuse me, the BOA Notice Rule 203A requires the hearing to be published in at least 2 newspapers of general circulation. So there were 2 ads, but it was in the Sun papers, and I'm not seeing anything in the record that shows me that there was advertisement in a second newspaper. Now, it's not ultimately determined, because the issue of notice, although there are rules and regulations, the issue of notice in what's called due process notice is sort of a very flexible thing. And who knew what when is really what's at issue. But I'm pointing at sort of like a sticky tape here, is that we didn't do both ads, and that was simply a mistake. And I'm just going to say here, in the last, my rules also say that even if they did not comply with the rules of procedure, and let me pull that up. If petitioner, Rule 4.3, if the petitioner has failed to comply with the public notice requirements, the hearing examiner may nonetheless proceed with the hearing if the hearing examiner determines that the petitioner has made a good faith effort to comply with the public notice requirements and the petitioner has substantially complied. The fact that the newspaper ads notice was in one newspaper is one thing, but I also noticed that these were done on 2 different dates. And to me, that's a really good faith compliance. It would be in any other case, if there were no motion to dismiss or a standing issue or any other case, that would not be a reason to continue the hearing, and these sort of notice requirements are never a reason to dismiss or deny unless it's very egregious. And yesterday I just pulled up decisions from about the last 5 years where I've spelled that out, and my comments here in my work session are consistent, and as everyone here knows, I'm always consistent, and if I'm not consistent, I have to think about why. So I think that the ads are fine, and so then we get to whether or not, which is really the crux. The crux is the petitioner or the appellant was required, since they're not the property owner, they were required to send a copy of the petition and time and date of the hearing, and there's nothing in the file to indicate that that occurred. And when I came in this morning, I just pulled the prior case, that a prior case that I heard, 7470, which was an appeal by the same appellants about an FDP issue. And I noticed that in that file, I just had it, and let me pull it out. That the appellant, the same appellants in this case as in this 747 did send a copy, and they did certify. All I'm taking from that is appellants, and just the fact that the appellants have appeared before me multiple times. I'm not assuming anything. I'm assuming that what am I assuming? I know that in the past that these same appellants have been aware of that and they complied with that. And then on June 19th, I received a copy of by Two Farms, a copy of a request for postponement and a motion to dismiss for lack of standing, and a request for, or alternatively, could I have a second, because I'm not seeing that. 1 second, am I seeing the motion? I'm not seeing a copy. Do you have an extra copy of your motion? I'm not seeing a copy of that motion in the file.
They were both under one cover letter.
Yes. And the motion, the June 19th motion to dismiss, and let me go back and explain why the June 19th date is important, and that is Hearing Examiner Rule 7.5 preliminary motions. A party may request the hearing examiner to address a preliminary matter, and the key terms here is that they the person filing the motion has to send written notification certifying that to the parties or interested parties that any person interested in responding to this motion must file a written response with the hearing examiner within 15 days of that motion that was filed. And in the 12 years that I've been here and looking back at, I have almost all, but not all, the prior hearing, 8 years of prior hearing examiners, that this 7.5 rule has always been strictly enforced. I quickly did a search again of all my decisions and orders and responses to motions, and in every instance where I could pull something up, and I looked at about 11, including almost every motion from an attorney with the initials of AA, Alexander Adams, who always files motions late. I consistently deny motions when they haven't met that 15-time date, because it's really critical that the person to respond has time before the hearing to respond, so that when I convene the hearing, I really have a clear sense of the issue in the motion to response and the response. And here it appears that, based on what I'm seeing in the file, I don't get the file until the morning of the hearing, and generally the board administrator doesn't review the file for ads and postings until the morning of the hearing, or the day before the hearing, when it's brought over. And so the question here is, may I entertain the motion to dismiss, and is it timely if it was submitted on June 19th? And the motion to dismiss says they didn't know of they didn't get a copy of the petition until June 19th.
And if I may, Madam
No,
Mayor,
sir, you
examine-
may not.
All right.
I'm just speaking into the record so people understand my reasoning. And you know, we've had issues with other decision-making boards that don't deliberate why they make a decision, and that's the sole reason why I'm here. And so the issue to me, it could be simple. Yes, the motion wasn't filed timely enough. But I am also, because, as I said, if I need to in a final decision in order, you know, I've also looked at, in past cases, I've also looked at what is the purpose of notice. And I have tons of cases when I was hearing code enforcement where the DPZ zoning inspectors were really negligent about noticing people who property rights were severely affected because they didn't send them petition. And I was always throwing things out. On the other hand, where there was a documented history and understanding of what the issues were about, and there's some understanding of what the real issue is, I have not, in both those zoning cases and it's really coming out of the zoning enforcement cases. I've looked at the Maryland and federal case law, which again says notice is a flexible thing, and it sort of all depends. And to me, what I'm sorting out as I speak is, okay, Mr. England, the appellant, there's nothing in the record to show that the appellants did the certification and affidavit. But I have emails going back to, scheduling emails going back several weeks, back to, one second. Back to May the 9th, where the board administrator, Robin Regner, had sent emails to Mr. England, Mr. Cole, and Mr. Cole's, Kelly Wagner, what's her
Paralegal.
office, what's her?
Paralegal.
Paralegal, trying to get a date set in. And so on May the 9th, everyone is aware of this appeal. On May the 14th, Mr. England responds, because, and I don't mean anything negative about this, it often takes time for Mr. England to respond. On May the 14th, Mr. England says, yeah, he's good, and then the date, everybody is confirmed that this date is being set in. And in line with the case law about notice, I do not, and again, I'm not ruling yet. In every, the case law informs me, Mr. Cole, you know what was being appealed.
That's what I was going to
I'm
respond to.
sorry, you don't, you know, that's 766D. Why would we set in a hearing about a case and Mr. England being copied in? And what had happened before that was the planning board had approved a petition, and your firm was at that hearing. Your firm was representing the petitioner at the, and I will say it is the long time practice, and I'm going to say this, that when there is a petition that either the staff in the council office, I'm not saying names, PDF somebody a copy of the petition, so they have it to know about. I'm Mr. Cole. I don't want. Or the petitioner goes to DPZ and says we have a copy, and I have. I know that to be a long-standing practice of how that is. And so there is a long-standing and formal practice of, in terms of notice, a lot of wiggle room. And I will also say, and I didn't have time to do the research on this, I can't remember if it is a much earlier appeal, because there was a first life, ultimately this appeal concerns Two Farms' interest in building a gas station, convenience store, car wash on this site. And in a prior processing of this petition, it's either that, there was a prior planning board decision where they initially denied this because of traffic. And I'm not sure if it's in that case, because I didn't have time to pull the file, but there were two other cases. It may be related to the AAA car center. There was an appeal where the parties in front of me were there, and I think this is before you joined the firm, where your law firm, where the appellant, so I think it must have been, I'd have to go back and look at the records, but it's in my head, and I have it in an electronic note somewhere, where the appellant didn't comply with any of the notice hearings. They didn't do ads, they didn't certify, and everybody knew what the issue was. And so the question is, to what degree did you have to be on notice if I don't factor in you not having been formal and there being strict compliance with the certification? And is everybody following my thinking? To what degree then are you on notice of what the issue is? And I think you were on notice. I think that the history of this case in its prior iterations, the fact that Mr. England and your law firm had been present when the planning board approved this, and I could not, I could say, well, you could think that maybe they didn't approve that. But the general issues, I think, are clear to everyone, and that is what the case law is telling me ultimately to look at. It doesn't factor, it's not determinative. I'm thinking about this, 2 weeks before this hearing was scheduled, I said to myself, where's the motion to dismiss? And the reason I asked that is because, and again, it's not specific to your law firm, every law firm, and even myself, we have an internal calendar when we know things are due. We know that motions are due 2 weeks before this, and I had that in my calendar, and that's a standard practice with law firms. And why wouldn't you ask for a copy of the petition? Although that's not strict compliance. I think that everyone knows what this issue is here, what this issue is. I will say, not in the Two Farms defense, I will say that, and I'm not attaching any significance to this. Mr. England likes to bring in things in appeals over which I have no authority to consider, because Mr. England is very passionate about the certain issues. And although he is passionate about these issues, they are not within my framework to consider, because I don't make public policy. The legislature makes policy. And so there may be things in the petition that was filed, but had there been a motion 2 weeks ahead of time, Mr. England would have had the opportunity to respond under, to state why he felt he was aggrieved in compliance with which is what now, Howard County and Maryland law. And I just want to note here, and again, I'm not trying to disparage, I'm not trying to be acrimonious. I'm just trying to put my facts in order. In the motion to postpone, there was a note, Respondents' Council acknowledges a request could have been requested earlier, but the numerous appeal petitions filed by these appellants has made it difficult to differentiate one appeal from the next. I'm sorry, I don't buy that. That's, I have to differentiate them. That's why we hire attorneys. And as I'm saying this, I think you were too late. And so the motion to dismiss fails, and we're going to have a hearing on the merits. I'm not sure where that will be, and I'm going to say this very strictly. Mr. England, Mr. Cole, we are going to very, very narrowly deal with the SDP issue. I'm not going to allow all the public policy issues to come in. And I will say that, as you know, in the past, where I believe that the planning board did not sufficiently consider something or did not consider something as they were required to do, and I have in my head the FDP amendment for Wegmans, and I can't pull up the name. I'm just telling you, just as a courtesy, that I think if there's an issue that the planning board should have been looking at, it didn't. I'm going to remand it, but I'm going to retain jurisdiction. I know there's someone in this audience that doesn't like that, but that's the fair thing to do. So you don't have to go through the appeals process again, because if the planning board isn't doing their job, we shouldn't punish people. We should make them do their job. And so because when I believe that rather than just go, as I used to do, go on and make that decision on my own, if I believe that something should go back to the planning board, what I am saying just as a courtesy is that I hope when there's a hearing on the merits that you will initially focus on those issues. So rather than go through 5 or 6 hearings and at the end say we go back to planning board, I have a much better sense earlier, if something, it may be that it doesn't go back. But that we know that early on, and because what happened with Wegmans is that it went on for a very long time, and at the end I said, it needs to go back to planning board. So I'm not making a ruling, I'm just saying I think that for once, Mr. England, you get a hearing on the merits.
Oh, good. Thank you very much.
And I want to say this because I know people say, well, we don't follow rules and there's this rule and this rule. And yes, I want to change my rules, but I can't until I get the Board of Appeals to do it. And this is just, for those of you that may appear before the Charter Commission, surely they should look at whether or not the Board of Appeals rules has to be done through legislation, because no other board does that. I think that was done maybe when they became a charter county. And why are my rules done by resolution? Changes to rules of procedure are simply administrative, to reflect concurrency with law, to fix goofy things. I mean, they should not, and you've heard me talk about this in my earlier appeals, they should not then be used to radically change substantive matters. So if there's an opportunity to testify before the Charter Commission to say, look, can you look at that because there is something I believe in the Charter, let's do it. And let's just, every time there's a rule change, let's then just change our rules to reflect, a law change, let's just update our rules to do that. And I would like to do that. I wanted to do that when I first started, and particularly after when I started doing code enforcements, because there's a real sticky issue in my rules. So with that, I'm going to, Mr. England and Mr. Cole, we're going to look at dates. I'm now booking in September, but it'll be a Friday morning, and if I can find some dates in August, we will, because there's likely to be multiple hearings. And so this work session